I've read your stuff, and I've read your writings. I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with, and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow the government and private parties follow court orders. I suppose it's not, I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer, yes.
In some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure what if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months abuse.
Smart.
No.
I've read your stuff, and I've read your writings. I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with, and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a federal a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who were you talking about?
sir, I'm very skeptical. If it's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical
You're
of some
embarrassed
members of the
that you
Supreme
made
Court.
that statement, aren't you?
I'm
You're an
Senator,
officer
it
of the
doesn't sound
court.
like something that
You know
I
what
would
I'm
say.
embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil
Did,
in
right here,
the classroom,
on
sir.
your podcast, April 22nd, 2024.
Okay, well,
Big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
Thank you, Senator Kennedy. Senator Durbin.
So I'm going to give the panel members an opportunity to.
What we just witnessed was not a casual exchange of legal theory. It was a moment when the veil slipped and the tension between power, principle, and personal ideology was dragged into the open, right there under the lights of a Senate hearing room. Senator John Kennedy did not raise his voice. He did not pound the table. Instead, he did something far more unsettling. He asked a simple question and refused to let it go. Would you ever advise defying a federal court order? Are nationwide injunctions being misused? And finally, when did it become acceptable to describe members of the United States Supreme Court as evil? That word hung in the air like a thundercloud. Evil. Not misguided, not mistaken, not controversial, evil. Spoken not by a fringe commentator, but by an officer of the court, a legal scholar, someone entrusted to shape the minds of future lawyers, judges, and public servants. And in that moment, the hearing stopped being about injunctions or Article 3 jurisdiction. It became a referendum on the moral temperature of our institutions. Senator Kennedy's frustration was not theatrical, it was surgical. He walked the witness back through her own public words, her own writings, her own broadcast. When she tried to retreat into uncertainty, into memory lapses and transcription errors, he pressed forward not to humiliate, but to clarify, because clarity matters. In a system built on precedent and restraint, words matter, especially when they come from people who claim to respect the rule of law. This exchange exposed something deeper than a disagreement over legal doctrine. It revealed how easily principles bend when filtered through personal politics. Kennedy laid out the contradiction plainly. When a president you oppose is restrained by a universal injunction, you applaud the judiciary. When a president you favor is restrained, suddenly the judges are politicians in robes. The law does not change. The Constitution does not change. Only the loyalties do, and that is the danger. Not disagreement, not debate, but selective outrage masquerading as legal reasoning. Nationwide injunctions did not suddenly become virtuous or corrupt based on who occupies the Oval Office. They either comport with constitutional limits or they do not. The witnesses ultimately admitted the truth under questioning. Both sides use them. Both sides forum shop. There are no clean hands here. Yet the most revealing moment came at the end when the discussion shifted from procedure to character. Calling Supreme Court justices evil is not a legal argument. It is a moral condemnation. And when moral condemnation becomes routine language for those sworn to uphold the system itself begins to erode. Kennedy's response was not academic. It was personal. "I'm embarrassed that you're teaching our kids," he said. Not because criticism is forbidden, but because contempt dressed up as scholarship poisons trust. This is the crossroads America finds itself standing at. Courts are meant to be imperfect, but respected. Judges are meant to be scrutinized, but not caricatured. When every decision is interpreted through the lens of partisan loyalty, the judiciary becomes just another battlefield, and the public is left wondering whether justice is blind or simply aligned. The hearing room offered a rare moment of honesty. One witness admitted she had not thought deeply enough about automatic stays. Another conceded that universal injunctions stretch constitutional boundaries even when the outcome feels righteous, and Kennedy himself acknowledged that trusting judges is necessary, even when trust feels strained. That is not cynicism, that is realism. This was not about silencing criticism of the Supreme Court. It was about drawing a line between principled disagreement and corrosive rhetoric. Democracies do not collapse in a single dramatic moment. They fray slowly through habits of language, through justifications that excuse today what would have outraged us yesterday. When legal experts speak as activists and activists speak as if they hold moral monopoly, the space for common ground disappears. What we saw was a reminder that the rule of law is not self-sustaining. It relies on restraint, consistency, and humility from those who interpret it. It relies on leaders willing to call out hypocrisy, even when it is uncomfortable. And it relies on citizens who are paying attention, who recognize that the health of the system depends not on who wins the next case, but on whether the system itself remains credible. In that quiet but charged exchange, Senator Kennedy did more than question a witness. He held up a mirror to the modern American legal culture. What he reflected back was not flattering, but it was necessary. Because once judges are reduced to heroes or villains based on political alignment, the Constitution becomes negotiable, and justice becomes conditional. This is why moments like this matter, not because they generate headlines, but because they force us to confront an uncomfortable truth. The erosion of norms rarely announces itself. It arrives through rationalizations, through language that crosses lines and pretends it did not. Today, it was one word: evil. Tomorrow, it could be something more. The question now is whether we learn from it, whether we demand consistency from those who claim authority, whether we insist that the law be more than a tool for the moment, or whether we allow ideology to hollow out institutions that took generations to build. If you believe transparency matters, if you believe accountability matters, if you believe the rule of law should outlast any single president, party, or professor, then stay engaged. Support independent coverage. And subscribe to Liberty Report USA, where we continue to expose the truth and defend the principles that hold this country together.